Thank you, Kathy. Good afternoon, everyone. Here we are again with our weekly webinar series. We're going to try something different today. At the end, we're going to have a question or two, or maybe a series of consolidated questions that we're going to try to tackle in sort of a separate session that we'll post and make available to everybody. Just a kind of a quick video that would cover maybe the most popular questions from today. Another program note regarding your questions, we try to answer those as best we can. A lot of times they are covered in our content. Other times try to get to them, but if we can't get to your question today, please contact your favorite bond attorney and have a conversation directly with them. We've got a lot on our plate today, so let's get started. We're going to start first with Kate McClung. Kate's a member in our Rochester office in the labor practice. One of the things that people keep asking about are scenarios under the Families First Act, and so we thought we'd have Kate pose and answer some of those questions today for us. Kate, good afternoon.
Good afternoon, Pete. So this is really an advanced Families First session. We've already covered Families First in previous webinars as well. But if we could advance to the next slide, that would be great. So one of the questions we've been getting is, we're starting to look at reopening. When can our rehired employees use Families First leave? So one example we're going to go through, if we could advance to the next slide, is that Paul was hired for a full-time position by your company January 1st of this year. He was then laid off on March 15th. And you rehire him on May 15th when you first reopen. On his first day back, he asks for emergency paid sick leave and emergency FMLA leave to care for his children. Is he eligible on his first day back? So as you may recall, the eligibility for the Families First Act for emergency paid sick leave, or EPSL, employees are immediately eligible for that leave. For the EFMLA, the Emergency Family and Medical Leave, they have to be employed by you for 30 days. So what does that mean for a rehired employee? Well, the CARES Act addressed that and said that rehired employees immediately are eligible if they meet 3 criteria. They have to have been laid off on or after March 1st. They have to have worked at least 30 of the last 60 calendar days prior to the layoff. And they need to have been rehired by the same employer. So that's when they're eligible. They can start taking this leave probably right away when they come back. Now that may cause you to question, okay, if they can take the leave immediately when they come back, can we factor in how likely they are to use that leave in deciding whether or not to hire them back? And that would be a risky thing to do, because then you could face liability for interfering with their rights under the Families First Act. So that really shouldn't be a consideration in whether or not. Okay, so if we can advance 2 slides. What if we reduce employees' hours? This is something that you may be looking at as you reopen. Maybe you're rehiring people for fewer hours, or maybe you've been open as essential this whole time, but you've reduced employees' hours. So looking at this on the next slide, Anne typically works 40 hours per week, 10 hours per day, Monday through Thursday. On May 1st, her employer reduces her schedule by eliminating her Thursday hours. So she decides to ask to take EFMLA leave on Thursdays. Is she eligible for that? And the answer is no. The guidance from the U.S. Department of Labor says if you reduce an employee's hours, they can't then apply for EPSL or EFMLA for those hours that were reduced. But another situation that could come up, so Anne's turned down for Families First leave, but now she comes back to you and says, well, my husband's been caring for our children since mid-March, but his company's reopening, so I really can't work at all. And so it sounds like she's probably eligible for EPSL and EFMLA due to her childcare needs. She can't work at all, so how do you calculate how much leave she gets per week? And there, the guidance from the U.S. Department of Labor is that you look at a series of things. So you look at her normal schedule. If she doesn't have a normal schedule, you look at her 6-month average. If she hasn't been there 6 months, you look at the agreed upon schedule at hiring. And if there was no such agreed schedule, you look at the average work schedule for the entire period of employment. Here, Anne did have a normal schedule. It used to be 40 hours, now it's 30 hours. So which normal schedule do we use? The U.S. Department of Labor said you would use the old normal schedule before the reduction. So under this circumstance where she can't work at all, she actually can get the full 40 hours each week under EPSL and EFMLA. Another question that's going to come up pretty soon for everybody is, okay, if Anne continues her EFMLA leave into the summer, can she do that? School otherwise would have been closed. So her school isn't unavailable because of COVID-19 anymore after that last scheduled day of school. Can she still take EFMLA leave? Now, what the U.S. Department of Labor has said in its guidance is no, she can't take EFMLA leave into the summer based on the school closure because the school is closed anyways. It's the summer vacation. But she may be eligible if her child care provider for the summer is closed. And they explained that if her child is enrolled in a camp or other program over the summer and that closes, she could be eligible for that reason. But keep in mind that the documentation you already got from Anne that says, I need FMLA leave because my school, Mendon Road Elementary, is closed due to COVID-19, that documentation isn't going to be effective over the summer anymore. It's a new reason, a new care provider has closed. So make sure you get new documentation from employees when you switch from the school year into the summer. Okay, next slide, please. So in addition to reducing employees' hours, some companies are reducing the employees' pay. That's something else that you may be doing as you rehire employees or just due to changing business needs. So on the next slide, we're going to see Tom's regular rate is $30 per hour. On May 20th, he reduced his regular rate to $25. And on May 30th, he asks for EPSL because he's experiencing symptoms of COVID-19. So what regular rate should you use in calculating his EPSL? Should it be the $25 an hour or the $30 an hour? The answer is actually neither. If you go to the next slide, the U.S. Department of Labor's guidance says that you calculate regular rate as the average regular rate over all full work weeks during the 6-month period ending on the first day that EPSL or EFMLA leave is taken. We could jump to the next slide, please. So for Paul, his regular rate during the 6-month period prior to his leave was mostly $30, then it decreased to $25. So when you take the average, it's going to be a bit under 30. Oh, we went too far. One slide back, please. If Paul's been employed for less than 6 months, then you would use his average regular rate for the entire period of his employment. And keep in mind, for a lot of your employees, their regular rate is going to vary from week to week. So this may not be that straightforward of an equation. You also have to keep in mind that we're calculating the regular rate, which may be different than their straight hourly rate. It can include other types of compensation as well, such as non-discretionary bonuses, shift differentials. So make sure that you're really calculating it using the regular rate. If you just use the hourly rate, you may end up underpaying employees. And the statute does permit just one employee to bring a class or collective action on behalf of a whole group of employees against you. So it's very important that you get the calculation right. Okay, so Paul returns to work after 2 weeks. 6 months later, he's still earning a regular rate of $25 per hour. So he's been earning that for a whole 6-month period. He asked to take EFMLA leave to care for his children. What regular rate should you use in calculating his EPSL at that point? You have to recalculate for that 6-month period before he takes leave. And the answer is no. Once he's taken any type of EPSL or EFMLA leave under the statute, you can use that calculation. You don't have to recalculate it each time the employee takes leave. So he's still going to get that regular rate that's just a bit under $30 an hour based on our last calculation. Okay, next slide. So as you can see from examples, the calculations here can be a little bit complicated. So it's important to check if you're taking the correct tax credit. So on the next slide, you'll see that you want to make sure that you're taking the full amount of the tax credit, which is 100% of the qualified EPSL or EFMLA And you want to make sure you're calculating that right. If you over-calculate it, then you're taking more of a tax credit than you're entitled to. If you under-calculate it, you're not paying your employees enough and they could sue you. So there really isn't any wiggle room. You want to make sure you get that right. You're also entitled to two other components of the tax credit: the employer's share of the Medicaid tax on those qualified wages and the allocable qualified health plan expenses. If you're having your payroll, you want to make sure that you give them that health plan expense information. That may not be something that you normally provide to them, and you want to make sure that you're getting the full tax credit that you're entitled to. Again, you don't want to take too much by miscalculating the wages or by accidentally taking a tax credit for the New York COVID-19 law. The tax credit is only for the Families First Act, the federal law. Make sure that you're not putting the New York COVID-19 leave into the same payroll code as you're using to track the better leave, because then the payroll company might think that they should take a tax credit for everything. And that's everything for me, Pete. Thanks so much for the time.
Thanks, Kate. The number one question appears to relate to the PowerPoint slides, and unfortunately we were having a little lag time and a little difficulty with that. I think we've generally done pretty well with the technology, but today's a little bit more of a challenge. So apologize for that. And the slides will be, available after. So Kate, thanks for that. A lot of good answers to difficult questions. I think one of the things that maybe bears repeating is, this is a lot like the FMLA, hence the name, but it requires that case-by-case analysis that we kind of go through and figure out what's our situation and what are the rules. I guess that's probably the number one lesson, Kate, that I would take away from hearing you go through the scenarios.
Yep, that's correct.
All right, let's go to Mary Aldridge. Mary's in our Buffalo office. She's got some observations and tips regarding employees working remotely. And I'm going to hazard the guess here that pretty much everything that Mary talks about would also be applicable to employees who are working in the office. So think about this in a couple ways, but the angle here, or the focus, is really going to be on remote work. Mary, go ahead, take it away.
All right, thanks, Pete. So like Pete mentioned, I'm going to talk briefly today about remote work arrangements and some of the challenges that go along with them. So remote work used to be the exception rather than the rule, but now that has been completely turned on its head. In response to the COVID-19 crisis, many employers had to make an abrupt shift from managing workforces that are 100% remote. I'm sure I don't have to remind you that this is not an easy task. In the next few minutes, I'm going to cover some legal requirements and best practices for employers to effectively manage a remote workforce, specifically with respect to the topics that are listed there in the slide. All right, next slide, please. So the Fair Labor Standards Act and any applicable state wage and hour laws are still in effect with respect to remote employees. Compliance with these laws in the remote work world can be tricky. This is especially true with respect to non-exempt or hourly employees. Under the FLSA, non-exempt employees must be paid at least minimum wage for all hours worked and at least time and a half for all hours worked in excess of 40 in a work week. The FLSA also requires you, the employer, to keep accurate records of all hours worked and wages paid. When an employee works from home, the line between working time and non-working time is not always clear. As the employer, you should communicate to your employees what types of activities constitute work time. This should include any work-related task, anything from picking up the company mail to checking work email on your cell phone. You should instruct employees to record all time spent engaging in these activities. Under the FLSA regulations, if you, the employer, have a reasonable belief that a non-exempt employee is performing work, you must count that time as hours worked and compensate the employee appropriately. As a reminder, if the employee works overtime without authorization, you may discipline the employee, but you cannot refuse to pay them for the overtime hours actually worked. Although the FLSA does not require meal periods, New York law specifically does. You must make sure that your employees are taking their legally required meal breaks even when working remotely. This is something that can easily fall through the cracks. Remember that employees should be completely relieved of their work duties during their meal periods. And like with overtime, if you have a reason to believe that an employee has worked through a meal period, you may discipline them, but you can't refuse to pay them. Next slide, please. All right. So even when employees are working from home, it's important that they maintain a safe working environment. You should instruct employees to designate a workspace and maintain that workspace in a safe condition that does not pose a danger to the employee or any company equipment. Employees should be instructed to report any job-related injuries to their supervisors immediately. So even in the remote work world, workers' comp may still be in play. As you probably know, workers' comp benefits are governed by state law and are provided to compensate employees for on-the-job injuries. Generally, employees are eligible to receive benefits for occupational injuries that arise out of and in the course of employment. Now, if a remote employee gets injured, it could be difficult to determine whether the injury arises out of and in the course of employment, as the law requires. There's not much precedent on this issue, but I found two interesting examples to share. So first of all, an Oregon court held that a JCPenney custom decorator was entitled to benefits under that state's workers' comp law after getting injured while walking from her house to the garage for the sole purpose of performing a work task. On the other hand, a Tennessee court held that a remote employee was not entitled to benefits when she was assaulted by a third-party intruder while preparing lunch in her employer-approved home workspace because the injuries did not arise out of her employment. This is a real case. So let's do what we can to keep our remote employees safer than these unfortunate individuals. All right, next slide. So maintaining confidentiality and cybersecurity can be difficult when employees are no longer contained in an office setting. Your employees must be aware of their general obligation to safeguard confidential information and how this plays out in a remote setting. You may even want to implement specific guidelines to ensure confidentiality of information during this time. For example, you could specify what files or other items are acceptable for employees to remove from the office and take home. You could also direct employees to conduct certain calls or video meetings in a private space and place all files in a desk or a cabinet instead of leaving them out in the open. There has also been a substantial escalation of cybercrime and cyber intrusion attempts during this crisis. Phishing emails have been particularly problematic. As I'm sure many of you have seen, hackers will commonly try or attempt to steal credentials by tricking employees into clicking attachments or links that request their information. Employees should be reminded to report any suspicious emails that they receive. It also might be worthwhile at this point to renew employee trainings on how to spot phishing emails or other hacking attempts. All right, next slide, please. Next, I'm going to talk briefly about reasonable accommodations under the ADA. You may already be familiar with the remote arrangement as a potential accommodation in and of itself. These days, however, most employees are working remotely not as an accommodation, but because they have to in response to the virus. Keep in mind that in certain circumstances, you may need to accommodate your remote employees in other ways. For example, if an employee needs some sort of special equipment to perform the essential functions of his job while in the office, he might need that same equipment to do so at home. It's easy for remote employees to become out of sight and out of mind, which could leave you vulnerable to a failure to accommodate claim under the ADA. So please make sure that you are engaging in the interactive process as necessary. Next slide, please. Lastly, you may encounter some general challenges with professionalism when managing remote employees. You should set clear expectations regarding when and how employees must be available and communicative. For example, your employees should understand when they are expected to answer the phone or respond to emails for work-related matters. Additionally, it can be uniquely challenging to manage dress and appearance with remote employees. On first thought, it seems awkward to dictate what employees can wear in their own homes. However, the reality is they are still working and must present themselves professionally. This is especially true for employees who have job responsibilities such as video conferencing with clients or teaching webinars, for example. You may even want to consider implementing a telecommuting policy specific to the COVID-19 crisis that memorializes these points and other topics that I've discussed. If you need any assistance with drafting a policy that's tailored to your company's needs, please reach out to your bond attorney and we are happy to help you with that. So that is all I have. So I will toss it back to Pete Jones.
Thanks, Mary. I think, again, I said it before you started, I think it's the case. Much of what you said, perhaps all of what you said, is really applicable in the brick and mortar workplace as well. But there are some nuances in the remote workplace. The professional dress, for instance, or the connectivity issues and those sorts of things. So again, our general principles will take us a long way, but we're going to need to be flexible as we apply those. So let's move on to Chris Kurtz. Chris is a member in our Garden City office. And we've been talking a lot about the pause and unpause and phase reopening. And Chris is going to focus a little bit more specifically today on the public sector. I may add a few comments, compare and contrast to the private sector, but Chris, take it away.
Thanks, Pete. Yeah, this is actually my first time on the webinar, so it's good to speak with everybody. As Pete said, I represent a lot of public sector employers, particularly down here on Long Island, where I am, and then also in Westchester County. And in that regard, we're really sort of right in the heart of this COVID-19 fight. There's a lot of information that's being thrown at us. We're hearing a lot of this 30 executive orders. There's federal programs, there's federal legislation all being passed. And it's hard sometimes to sort out what's really applicable to us. Is all of it for us? Some of it? What must we do? What should we do? What might we do? And I think it's important to get back to basics. And for a lot of the public sector employers, and particularly the municipal employers, I get a lot of questions about the New York on pause and a lot of questions about reopening. For us, for municipal employers in New York State, New York has not been on pause. We're not stopped. We're not frozen. We are sort of in slow motion. I kind of like to think of it, it's almost like, you're watching Netflix or whatever, and, if you hit pause and go get a drink, everything stops. If you hit play a couple of times, you're grinding through a little bit slow. And we all know this. We all know that we still have police. If we call 911, police will respond. If we call for fire, they'll respond. Our garbage is getting picked up. So, in that regard, unlike the private sector, the public sector is still slowly moving along. We have personnel restrictions. We don't have business restrictions. The government did not look specifically at the industry and say this is essential or not essential. It's telling us within what you do, governments determine who is essential and who is not. So I think it's important to stick to those fundamentals. I listed there on the slide about 5 executive orders out of the group that really do apply to us as public sector entities. When the governor and the governor's office wants to use the term local governments, they use it in the executive orders. So they know how to, write that term. We can see when it's applicable to us, and we can see a lot of times when these executive orders are not applicable to us. If you would move to the next slide, please. If you want to go to our basics, to what is still applicable in the public sector, you got to go all the way back to 202.4, one of the first ones that came out from the governor's office. It was effective March 17th, and that workforce restriction still applies. It applies today, it applies tomorrow, it applied yesterday. And we'll talk a little bit more about whether it's going to apply past May 15th, and I think the answer is that it does. But again, this is, and if you read it right there, any local government or political subdivision, as of March 17th, St. Patrick's Day, must allow non-essential personnel, as we determine, as the local government determines, to work from home or take leave without charging accruals, except for those personnel that are essential. The non-essential personnel shall total no less than 50% of the total number of employees across the entire workforce. Now, I've been speaking with clients off and on. What does this 50% mean? How do you calculate it? There's a lot that, that's subject for another webinar or subject for private discussions to go through how to calculate that. Sometimes if you're in a small municipality, you might only have 30 employees, but 20 of them are police. Is that too many? Or do you look at how many are working per shift? So, we really go back to this. We hold this executive order to be the document that we have to follow continuously. We are not on 100% pause. If you would go to the next slide. The pause, New York on pause, came in executive orders 202.6 through 202.8. And if you remember, it was right after the March 17th came out for the workforce restrictions in the public sector. The private sector started to shut down. The governor took it to 50%, to 75%, and to 100% for non-essential businesses over really a 3 or 4 day period. It was by Sunday night at 8 o'clock on that March 22nd that all those non-essential businesses had to be closed. Those executive orders didn't apply to the public sector. We were not on pause. The Empire State Development Corp., which is the agency that in the private sector, businesses would look to and say, am I on your list of pre-established essential businesses? Great, I can stay open. Or am I not on that list? And should I apply to you to see if I can be covered? And that has probably been the subject of prior webinars. Local governments didn't do that. Local governments didn't write to the Empire State Development Corporation and say, hey, am I allowed to run my village? Hey, am I allowed to run my town? Those were for the private sector entities. They looked at the nature of the business itself. If you're a barber, we determine that you're not essential, your business is not essential, you must close 100%. They did not look within the barber and say, well, you know what, the barber himself or herself, well, that person's essential, but the guy who sweeps the floor or the person who works the cash register, they are not essential. That's kind of what happened a little bit with the public sector, right? So it's important to have a little bit of backup, and you can see from the guidance there on 202.6, and then a frequently asked question, which is also within the Empire State Development's frequently asked questions, that state and local governments are not covered by this 06 to 08 New York on pause. And that's important because it's those on pause restrictions that have been continued. It's those on pause in terms of the nature of your business restrictions that are now being lifted or reopened. So if you would turn to the next slide, please.
Hey, Chris, while we're waiting for the slide to advance, so just to bring it into focus, and we've talked about this before, but there are you've got the essential businesses that are not governmental entities, okay, and they're open under the pause guidance. And then you've got the public sector entities that you're talking about. You're a second group that are subject to the reductions in numbers of in-person employees at work, but are not completely paused. Right. And then the third group are the people who are not essential businesses and have not received designation from the Empire State Development Corp, who are looking to be unpaused. And we've talked at length about the phased approach and the criteria for that. So I just so people are clear on the three different categories, and Chris is focused on that middle category right now, the group that was not fully paused, but put in, to use your analogy, kind of the slower motion situation. So didn't mean to interrupt you, but I just wanted to make sure we're clear about those three different groups because each one will have slightly different rules to proceed.
Yeah, that's exactly right, Pete. And it's important because I get a lot of questions from clients, public sector clients, as to what phase am I in? Well, what region? Well, where I'm in this region. I'm in the Mohawk Valley. I'm in Westchester. I'm in the Hudson Valley. I'm on Long Island. do I have to pay attention to all that? It's hard not to pay attention when it's on TV and it's in the news and in your face all the time. But we really are in that second category that is not subject to legally the pause and the reopening. What we are subject to is the continued restrictions. So in subsequent executive orders beyond 202.4, in 202.14, the governor took it out to April 29th. In 202.18, the governor took it out to May 15th. In the most recent one, 202.29, which was, he took it out, 202.4, to June 7th. It's important. I'm getting a lot of calls now. People are getting a little restless. All clients are. They want to reopen. They want to come back to work. They want to bring all their personnel back. Why do we have to keep paying everybody? It's 9 weeks in. Can't we get them to do something? And my mantra to them is still, we are still under the 50% restriction of 202.4. You still are abiding by that. I think the governor's office and then his press conferences this week, lent a little bit of confusion or questions about the New York on pause and whether that was continued or whether that's being open. But it seems pretty clear now, based on yesterday and probably today, that the New York Moving Forward or New York Forward program is in place, will be implemented, and has been in the Finger Lakes and for example, has not been on Long Island. But nonetheless, for us public sector, we live by the 202.4. Next slide, please. So, one of the ways that I try to simplify this a little bit for the clients when there's so much confusion about, where we're located, what phase we're in, I say, look, pause the TV, look at what's on there. Where do you see? You see phases 1 through 4, top to bottom. Where are we? Local government, are you in there? No, you're not. You're not there. Construction and manufacturing, you're in phase 1. You want to go to a Ranger game at Madison Square Garden. Well, you're in phase 4. See you next season. But local government is not there. And so, that should be another more practical help for you to determine. We don't have to, we're not waiting for us to hit 7 metrics in our region to reopen our public sector entity. I think it's fair to say that beyond June 7th, we will, at some point, come back to a full in-person workforce, right? We're not going to have a 50% restriction for the entire time. That may be phased in, it may be gradual. That may itself be regional, but we don't know that as of right now. We may see that, okay, for 2 weeks, you can bring back a total of 75% of your workforce. And then eventually we get to 100%. But, you really have to sort of stay tuned for that if you are a municipal government, and just sort of keep to our restrictions are in place with our personnel, and, remember, learn and keep track of these phases and all like that, but think about what's really applicable to you. And I have one final slide there that I think, and I referenced it in the title slide, that the 202.16, when you're looking for things that are directly applicable to us in the public sector, this is another executive order, and it deals with the face coverings for employees who directly interact with the public. The guidance on 202.16 made it clear that that applies to state and local governments. So, you have to take the plain reading of these executive orders. You have to look at, any guidance you can get, often from the Empire State Development or from the Department of Health, use that together. And I think that's important particularly for our public sector clients to remember at this point. Thanks, Pete.
Chris, thank you. I think that rounds out the picture nicely in terms of the various situations. Let's go to Katie Anderson. Katie's in our Albany office, has been following the updates from Albany for us. And I know earlier was, watching the governor. I guess he was in Binghamton today. So Katie, take it away.
All right. Yeah, no, he hasn't spoken yet, but at some point he's going to speak from Binghamton, and we're not sure when that's gonna be. So we did have, just another dizzying week from Albany in terms of reopening and in terms of what's coming out of the governor's office. So let's take, 8 minutes, and I'll try to break it down in a way that makes sense, hopefully, for most of you. first things first, we have news now that we're going to be reopening regions, but how and why is that? Executive Order 202.29 was issued on Friday, late Friday night, and that Chris touched upon this. It extended Executive Order 202.18. 202.18 is what originally extended New York pause to May 15th. Despite what the governor's office, so far has said, they did extend New York pause ultimately to June 7th. Now, that doesn't mean that obviously reopening is happening. Basically, reopening will be exceptions to New York pause. But if you are in a region that's not reopening, or B, you're in a region that's reopening, but you're not in the first phase, or even if you are in the first phase, you're still going to have to follow those restrictions that are in place. So that's just an important baseline to start from. If you are you're bringing back people, and we're going to touch upon that in a little bit. Just keep that in mind. So this chart that's up, the governor's office is going to be updating this every day now. This shows the metrics for where each region is. And as you can see, we have 3 regions, the Southern Tier, Finger Lakes and Mohawk Valley, that have met all the metrics, and 2 regions that are very close, Central New York and the North Country. Both of them are deficient or lacking the number of tests that they need, but as you can see, they're very close to getting to the number of tests that they need. So they could still potentially hit that May 15th date. So we're going to, see a lot of movement on this in the coming days, and looking to, close behind, we have Long Island, Capital Region, and Western New York. So what are these phases then? What is in phase 1? The governor's office has provided some more guidance as to what phase 1 involves. Hasn't provided this level of guidance for the rest of the phases. So I'm not going to be touching on, phase 2 quite yet. I covered that last week. And we can, there's lots of our information memos are out there that list all of that information. But there's one link on this that's going to be really important to keep looking at. It's forward.ny.gov. This is where the governor's office has all of this information about reopening. That link didn't work until probably 12 o'clock yesterday. So it's brand new. I expect that it will be developing over the coming days. Phase 1 for construction, you can see it's pretty detailed as to what it involves. We're just going to kind of go through these quickly because all of this is, again, available on the governor's website right now. You look to agriculture, forestry, fishing, that importantly includes support activities. And so what that entails, we don't know yet at this point, but we expect to get further guidance on that issue. You look to retail, curbside pickup. Broadly, this is, your brick and mortar stores will now be able to be open, which is very exciting for me because I have run out of books. So I will be, heading over to one of those places, to a bookstore, to be able to pick one of those up. Next up, you have manufacturing. These are, the reason that I want to show these lists is that they're very detailed. And part of that is good that we have guidance as to what, manufacturing involves. But part of it means if you're not on that list, it's going to be harder to get on there. And if you're not on that list, get in touch with us and we can, see about trying to get you on there. And, finally, you have wholesale. And, this is, again, just more of the same, more of a lot of the questions. So this is what I really wanted to get to. Looking to what do you have to do for reopening? I came up with this mnemonic device today. I have to congratulate myself on it. No, I'm kidding. This is taken really from what the governor's been putting out there about what every business, not-for-profit entity, public entities likely will need in order to reopen. It's a reopening plan. And part of that reopening plan, they have to include, there are 4 key components to it. The governor's office lists 3, I add a 4th. First one is protections for employees and customers. How are you dealing with employees interacting with each other? Are you giving people face coverings? Are you putting up the shields if you're having interactions between them? Are you able to institute social distancing? Those are all very important issues to be working through in your mind. Second is the layout of your workspace. How do you have to change your workplace in order to accommodate people, in order to accommodate social distancing? Do you have to remove your public furniture so that people aren't all sitting in the same chairs? Your break rooms, do you have to, how are you going to rearrange that to allow for enough people to be in there with adequate social distancing? And how are you going to be cleaning those things? The third one, adaptive health protocols. How are you going to be screening employees? How are you going to be, dealing with symptoms of COVID in workers? How are you going to be sending people home? A lot of you likely have these in place already. So that's what leads us to the 4th factor. The 4th factor is write this down. Write down what it is that you're doing right now. If you are an essential business, if you're operating, if you're not operating in person at this point, write it down. And then the number one thing that you can do is, send it along to us and we can take a look at it to go from there to make sure that it's up to snuff. At this point, there's a few outstanding issues. One, we don't know if these plans are going to have to be submitted to anyone. It's unclear. We've received, there's no guidance on that, but it is clear that you need a plan. So the plan should be written in case somebody says you need this to reopen, or in case somebody says, where's your plan? Let me see it. We know that reopening at this point is really going to be governed by localities and the regions that you're in. So look to them for guidance as well. And I think that's it, unless, P, I see there's quite a few questions. So feel free to ask me that.
Yeah, I can just consolidate a couple here. One is, are the phases only applicable to the regions? And another is, do you advise having a plan in place if you have remained open as essential? I think the answer to both those questions is yes, but do you want to elaborate maybe just a little?
Yeah, so looking at the regional reopening part, part of that is, if you're not in that region, then your phase hasn't begun yet, right? If you're in the capital region, like I am, our phase hasn't, we're not going to be entering phase 1 for a little bit. Not sure when, but at some point. So once you've entered that phase, what does that mean? Can a manufacturing plant bring back all its office staff at that point? To me, it doesn't, we haven't received much guidance on that, first of all. But second of all, if you look to phase 2 includes administrative office support. To me, that indicates that phase 2 is when you will be starting to bring people back into the office space in that capacity outside of phase 1. The second question was, I forget at this point.
Well, it relates to having a plan in place, and I think you had already mentioned this, but I mean, I don't think when the pause initially happened, there was much guidance on having a plan in place if you were essential.
Yeah, yeah.
Go ahead.
Right. No. I mean, it's good. Essential businesses should have a plan in place, because at this point, an essential business is only to be having those workers there that are necessary to support those essential functions. So presumably you don't have your full workplace there in place, even if it's, presumably at least a subsection of your workforce is working remotely or not working. So you need to have a plan in place as to how you're going to be bringing those people back, but also how you're going to continue to protect your workers and continue to guard against COVID-19 in the meantime. I'm assuming that most of you have protocols in place that are likely up to snuff, but it's just the factor of just writing them down. That will be big.
Okay, let's move on to Rod. Rod McDonald is a member in our Syracuse office, and we've made this a weekly feature as well. Tax credits, loans, the PPE program, just updates and things to keep in mind. The PPP program deadline's been extended. Rod, take it away with your thoughts, please.
Thanks, Pete. So with all the timely news on reopening that Katie just covered, it feels like my topic is a little bit old news. It's hard to believe that I think I presented on this 2 weeks ago, and the PPP seemed like the hot topic. The SBA had just come out with new guidance the week before, most infamously FAQ number 31 on April 23rd, which told potential PPP borrowers that they must consider their ability to access other sources of liquidity when certifying that they need the PPP funds as part of the application process. And that very morning, 2 weeks ago, the Treasury Secretary had been on TV announcing that every loan over $2 million would be audited, and that people could face criminal penalties for false certifications on the loan application. And with that threat of a stick, the Treasury had also offered a carrot, providing that a loan obtained before the updated guidance came out could be repaid by May 7th, and that the SBA would then deem the certification made for the loan to be in good faith, kind of a safe harbor that they provided. So those developments led to a lot of soul searching and renumber crunching since that time. People were asking questions like, I have a working capital line of credit. Do I have to draw down on that rather than take the PPP loan? Or charitable organizations said that, we have an endowment. Do we need to draw down on that rather than take the PPP? Or if there's shareholders with means, should they be making capital contributions rather than their company borrowing? It was all very fact specific. Some clients did give the money back for various reasons. Some said, it was very uncertain when I submitted the application, but I was an essential business, or I was able to keep operating, and things are better than I expected. I know that the list of recipients is going to be published, and I don't want to be on it, so I'm going to give the money back. Others, there were changes in guidance that came out. There was definitely an ambiguity, I felt, as to whether a business said in a few different places. The SBA FAQ said to qualify, you had to have fewer than 500 U.S. resident employees. So if a company had foreign employees, did they have to be counted? And it wasn't clear. And then last week they made it clear you do need to count them. So that changes like that caused people to give money back. Some people just found that they had checked the wrong box on their application, and under the circumstances, they didn't want to keep the funds and face scrutiny. Many did end up keeping their PPP loan. They concluded they either didn't have access to liquidity, or more likely that it would be significantly detrimental, for example, to draw down on your line of credit completely or to spend your endowment funds. So a lot of people did keep the money, and for those that did, we recommended they consider their spending for the rest of the year. People are going to be, it's going to be Monday morning quarterback looking back over your shoulder, a year or two from now, or maybe longer, when these are being audited. And so, you really want to have thrown a lavish holiday party or paid significant executive bonuses this year? Probably want to be pretty conservative if you're keeping the PPP money. So what's new with the PPP since last Tuesday? Well, last week, the SBA extended the safe harbor, the deadline to pay back funds from May 7th to this Thursday, May 14th. That in the FAQ, when they did that, they said there will be additional guidance on how the SBA will review the certification that's supposed to come out before this Thursday. As of yet, we haven't seen that. So everyone's looking for that. But so there's a few more days for people to agonize over what to do about their PPP funds. There's still funds in the program. What I've been reading, the pace of applications has slowed down. The size of the loans that are being granted are smaller, and some people have returned money. So people are still applying. And the SBA continues to come out with more FAQs. The most recent one was May 6th. And the thing that we are still awaiting guidance on with bated breath is more guidance on the loan forgiveness that was supposed to come out, I think last Monday, and it's still not out. People are really want to focus on and understand what the rules are for forgiveness, whereas right now there's still a lot of questions. For an example, there's been criticism of the requirement that the SBA says 75% of the funds have to be spent on payroll in order to qualify for forgiveness. And that's been criticized. And I think on Friday, the SBA Inspector General issued a report and said, hey, the CARES Act doesn't mandate a specific amount to be spent on payroll. So that 75% may be cleared up in the guidance. We don't know. So stay tuned for that. And then Pete mentioned tax credits. I'll briefly mention the last FAQ that came out said if you received a PPP loan and pay it back by May 14th, then you're eligible for the employee retention credit. You can't get both the PPP loan and forgiveness and also the retention credit. So if you pay it back, you may be able to take advantage of the credit. This is for 50% of qualified wages paid from March 12th to the end of the year, up to $5,000 per employee. There are requirements for eligibility for that. The business had to be fully or partially suspended due to a government order or a significant decline in gross receipts quarter over the prior year's quarter. And information is still coming out on that credit. Just yesterday, the updated Form 941 was released, which shows you how to apply for that credit. And then I guess finally, even if you don't qualify for the employee retention credit and you don't qualify for a PPP, you can still defer payment of the employer's 6.2% share of the Social Security tax on wages paid from, I think, March 27th to the end of the year. And half of that deferral would be due at the end of 2021, and the other half would be due at the end of 2022. So that's a resource out there as well for people who aren't otherwise eligible for some of these other programs. And with that, I'll turn it over to the Q&A, Pete. Thank you.
All right, Rod, thank you. Complicated issues, not incomplete guidance, an evolving situation. Those are, they're tough for employers that would like to have some certainty. Like every other aspect of this crisis, I think there's a lot of things that are just not, can't be specified with certainty. That's going to do it for us today. Thank you, everyone, for getting on. Thanks for staying on. We appreciate you as clients and friends of the firm. We'll be back at it again next Tuesday with additional updates. And as I mentioned previously, we're going to try and take a few questions from this webinar offline, and we'll post some video clips on that. Thanks, everyone. Have a great day. Stay safe.